Thank you for joining today to discuss agreements between library boards and municipalities. My name is Natalia Pietrikowski, and I'm a library legislative advisor with the Public Library Services branch. Although our branch works with library boards and staff across the province to administer the library's legislation, we are not lawyers. For some questions on this topic, it may be best to seek out a legal opinion. Today, we'll be talking about the relationship between the library board and the municipality, when you should have an agreement, and why you may consider it important to have one. Elements that should be present in all agreements, regardless of the working relationship between the two bodies. Potential agreement elements related to personnel, if your municipality is providing benefits or HR support to your board, there are some things to consider. Potential agreement elements related to finance. If your municipality is providing accounts payable, accounts receivable, or bookkeeping, there are some items to consider. Potential agreement elements related to facilities. If your municipality is paying for utilities or facilities maintenance, we'll provide some items to consider. Let's start with a look at the library board and the municipality and why agreements between them can be important. When a municipality passes a bylaw to create a library board, the board automatically becomes a corporation under Section 3.4 of the Libraries Act. This means that the board has power to do things like hire staff, enter into contracts, sue, and be sued. It also establishes the board as a legal body independent of the municipality. While the Libraries Act gives the municipality certain powers over the library board, such as the sole ability to appoint and unappoint board members, the board still has the responsibility to manage its financial and administrative affairs independently of the municipality. The board and the municipality are separate legal entities, each with their own authority and autonomy. The scope of authority of each body is quite different. Library boards have full authority over the delivery of public library service within the community, as stated in Section 12.4 of the Libraries Act. Municipal councils have authority over other municipal services in the municipality. As separate corporations, the board and council each have autonomy over their own affairs. So, no part of any board-municipality agreement should reduce or restrict the authority or autonomy of either corporation. Although only the library board has authority over library service in the municipality, both board and council hopefully share the same desire to see effective library service in the community. Because of this, the municipality may choose to support the library board by providing services in addition to local appropriation. The municipality often has greater capacity to provide financial and personnel services than the library board, and often owns the building where the library board provides library service. As we've said, the board and the municipality are separate corporations, each with their own responsibility to manage their own affairs. This includes managing their own financial matters, personnel, and facilities. It is reasonable for the municipality to want to support the library board by providing services as well as a local appropriation. However, because the board and the municipality are separate corporations with separate authority and responsibility, boards and municipalities should enter into a written agreement whenever the municipality takes on work on behalf of the library board. Why else is it important to have a written agreement when the municipality does work on behalf of the library board? Agreements provide clarity of roles. The board and the municipality should each know what their roles are in this relationship and have clearly defined expectations of one another. It's a mutually beneficial agreement. This sort of relationship should be of benefit to both parties. Having a written agreement helps to ensure that both the board and municipality gain clearly defined benefits from working together. And finally, this is a way to avoid legal problems. Managing a corporate relationship on unspoken terms can lead to uncertainty, confusion, and even legal issues. Now let's take a look at the essential elements of any library board municipality agreement. Every agreement should be based on local circumstance. Before you begin drafting your agreement, take stock of the services that your municipality provides to your library board. What specific services is your municipality providing to the board? Are there any services that aren't covered under personnel, finance, or facilities? While it can be helpful to consult other agreements for sample language, make sure that your agreement reflects the local arrangement between the municipality and the board. Every local situation is going to be unique, and there isn't one single template that works for everyone. That said, there are some clauses that all board municipal agreements should most definitely consider including. All agreements should include a statement of roles. This should confirm that the board has full management and control over library service in the community as per Section 12.4 of the Libraries Act. This means that library staff are employees of the board. The library board needs to have control of its financial accounts, and the board is responsible for managing the activities in the library building, even if the building is owned by the municipality. This section should also identify the municipality as an administrative service provider to the board. Include a full list of all services provided by the municipality. Also include any payment terms for those services, if any. If there are payment terms, include sections on how payments will be received and by what date. Municipalities should not use the duties listed in board municipality agreements as a justification to reduce annual local appropriation funding to the library board. Here are some other important elements to consider including into any agreement. Include a statement that each party recognizes and accommodates, as much as possible, each other's priorities. This agreement will require flexibility and compromise for both parties, just like any other agreement. Include a section on how to manage a dispute between the two parties. If the parties can't agree on something, how will that be managed? Will you need to take a second look at the agreement to ensure future revisions of clauses are clear and unambiguous? Include a statement on how to manage a breach of the agreement by either party, including how such a breach might be waived. How might both of you carry forward with this agreement if the terms are violated, especially if such a breach is an honest mistake? Include statements defining how often the agreement will be reviewed and how amendments will be considered, reviewed, and accepted or rejected. We suggest that the agreement should be reviewed at least once every 3 years. Between review dates, either party should be able to request amendments to the agreement and have those amendments incorporated into the agreement. Include a statement on termination. Either party should be able to request that the agreement be terminated. The termination should come with a substantial notice period if it is not mutually agreeable, for example, between 6 months to a year. This section should include a clause on how the agreement would be terminated in case of a breach of the agreement by either party. Next, we'll look at common services that municipalities provide to library boards, which are usually related to personnel, finance, and facilities, and what to consider when drafting agreements related to these services. Many municipalities provide personnel services to local library boards. This support could include access to benefits plans, insurance coverage, or human resources support to library boards. For the purposes of receiving these services, library employees may be considered municipal employees by the municipality. Despite this, library employees legally remain employees of the board and only the board. Under the Libraries Act, library boards have the responsibility to provide library service to the community. As corporations, boards have the ability to hire staff to manage and conduct the day-to-day operations of the library. Because boards are independent corporations and because library service is the responsibility of the library board, library employees are employees of the board, not the municipality. Some questions that the board and municipality might ask themselves if they wish to consider personnel services in their agreement include: what benefits package or insurance coverage, if any, will staff of the library board be eligible for? Are all municipal staff aware that the library staff still report to and take direction from their supervisor and/or the library manager, even if they're considered municipal staff for the purposes of municipally provided services? Are there circumstances where library board employees, including the library manager, would need to consult with and take advice from municipal administration for the purposes of meeting occupational health and safety requirements? And finally, does the library participate in any other municipal programs, for example, safety programs, joint promotional activities, etc.? Because the library board and the municipality are separate corporations, they each have a responsibility to independently manage their own financial affairs. However, depending on your local situation, the municipality may support the library board by providing some financial services. This might include accounts payable, accounts receivable, payroll services, bookkeeping services, or even holding bank accounts on behalf of the board. It may also include the municipality funding the board by direct payment rather than a cash transfer, which looks like the municipality paying certain operating costs directly rather than providing the board money to do so, such as a utility bill. Even if the board chooses to have the municipality provide these services, as a corporation, it still has a responsibility to manage its own financial affairs. In order to do this, the board must have unrestricted access to its own accounts and financial information. If the municipality holds bank accounts on behalf of the board must have access to those accounts, as well as access to reports and information that allows it to make independent decisions about its financial position and affairs. This remains the case if the board chooses to place funds it does not spend over the course of the year into a reserve account. The board should have the same access to information about its reserve account as its other accounts. If some of these funds were transferred by the municipality, the board should not be obligated to return money that was not spent. Here are some questions to ask if including financial services in a library board municipality agreement. If the municipality provides financial services to the board, how much control do library staff and board members have over services provided by the municipality? Is the board able to access reports and data on the services provided? Is the board able to provide any input on the provision of these services or suggest changes? Does the board have direct control over its accounts, or are its accounts held by the municipality on the board's behalf? If accounts are held by the municipality, how can the library board access these funds in a timely fashion? Does the board have a full list of all library board accounts that are held by the municipality? Does the library board retain full control over its accounts and financial position, even if those accounts are held by the municipality? If the board has a reserve account, does the board have timely access to its reserve account? Is the board able to allocate or spend its reserve funds as it so wishes? If library board staff are paid by the municipality, does the board have the authority to set pay rates for its own staff? Finally, let's take a look at services related to facilities that municipalities may provide to the library board. Although many public libraries are located in buildings owned by the municipality, there are various configurations of ownership. The municipality may own the building, the library board may own the building, or each may own part of the building. The tangible assets within the building too, for example, desks, shelves, equipment, etc., may be owned by one party, both parties, or each party may own a portion. Of course, all facilities come with ongoing maintenance costs to remain in operation. These include facility maintenance, repair, or replacement of tangible assets, and utilities. If the municipality owns the facility, it may be expected to handle at least part of the cost of ownership. However, this should be another area where both parties should determine who will be responsible for what, based on their local context and relationship. Here are some questions to ask regarding facilities when entering into an agreement. Who owns the facility? Who owns the tangible assets? Who pays the cost of utilities for the library? Does the library board have any say in the provision of these costs? For example, who the phone service provider is? Who is responsible for maintenance and maintenance costs? Does the board hold insurance for liability, either on its own or through the municipality? Hopefully this presentation has provided some food for thought when it comes to how library boards and municipalities can work together while respecting the authority and autonomy of each corporation. Both the board and the municipality have important work to do, and it is mutually beneficial to have clear and well-documented agreements to avoid any misunderstandings or challenges that may occur within this unique structure. Feel free to reach out to us at the contact information on the screen if you have any questions. Thank you.